Changes that the Georgia Association of Realtors made to their 2023 contract package mid-year, the mid-year revisions. GAR released their contract changes the beginning of June, and we are going to dive in and cover what those changes are. This is going to be the first in a mini series of videos covering the changes that the Georgia Association of Realtors did make. My name is Dana Sparks. I am the director of the Real Estate Academy of America and the qualifying broker of Maximum One Greater Atlanta Realtors. So if you have questions about either the school or the brokerage, please contact me and I'd love to answer whatever questions you may have. So let's continue on. This video is going to cover the changes that GAR made to the purchase and sale agreement. And I am going to go ahead in this video and show you the actual changes. I think rather than just talking about them, it's much easier as an agent for you to actually see the changes on the contract in context of what I am talking about. So hang on, bear with me, and let me share my screen and we shall get started. So going to share my screen with you now. And we, as I said, are going to cover the changes to the purchase and sale agreement. Now, how can you tell if one of the forms that you're working with is the latest revision and if it has been revised at all? Well, a couple of ways. The first thing is that GAR does release a change. They have a mistake there. Wherever it is that you access your purchase and sale agreements, they also have an index of the changes. And so now you can see this is called 2023 GAR Forms Revisions Package Changes. And it does say the following pages will list the changes from the release of the package that was released January 1st. So these changes were released. They have a typo there. That should say 2023, but these were released June 1st, 2023. So you'll get an index of all of the changes, and the ones we are going to talk about today are the mid-year revisions to the purchase and sale agreement. Now, when you're actually on the document itself, this is the purchase and sale agreement. It still says 2023 printing at the top, but here at the bottom, you will see the date, 6/1/23. So if it is a form that was revised mid-year, you'll have the date there. If not, it'll still say 1/1/23. So let's dive in. The first thing that GAR did was in the title section when it's talking about title insurance, and this is paragraph B1C under title insurance. GAR, the verbiage, it does say buyer directs mortgage lender to quote the cost of title insurance based on the presumption that buyer will be obtaining an enhanced title policy. That's the same. It used to say in January, since such a policy affords buyer greater coverage. Now it says, if such a policy can be issued on the property or for the buyer in the transaction. So that's just a slight verbiage change there. The next change they made is under the purchase price of the property to be paid by the buyer at closing. They did add, it used to just say purchase price in US dollars by wire transfer or immediately available funds. They have added this sentence or this phrase, by such method of delivery acceptable to the closing attorney. So a closing attorney is not necessarily limited to only accepting a wire. It is up to the discretion of the closing attorney, the funds they are going to accept for the purchase price of the house to be paid by the buyer. Now, under the closing costs section, basically what they did in June of 2023 is they sort of separated out some of the information into more discrete paragraphs, and they clarified the language for easier understanding. This part has not changed, where it talks about the seller's contribution to the buyer's closing costs. At closing, seller shall make the referenced seller's monetary contribution, which the buyers may use to pay any cost or expense of the buyer related to the transaction, including without limitation commission obligations of buyer. Buyer acknowledges that buyer's mortgage lenders may or may not allow monetary contributions or full amount thereof to be used for some of the costs or expenses. In such event, any unused portion of the monetary contribution shall remain the property of the seller. That hasn't changed. What has changed is it did also say in that first paragraph, in addition, it used to say, additionally, the seller shall also pay the fees and costs of the closing attorney, 1, to prepare and record the title curative documents, 2, for a seller not attending the closing in person, and 3, to handle and deliver payoffs and proceeds. Basically, they've just separated the additional items that the seller is required to pay separate from what the seller is paying in connection with any contribution to the buyer's closing costs. Additionally, the items that the buyer is paying, they did just change the verbiage slightly to make that a little more clear, so that everybody understands it, rather than using the formerly legalese that sometimes can be a bit more complicated than necessary. Moving on, in the section where it talks about the disbursement of earnest money, paragraph B, 7B. So this is a situation where the holder is holding earnest money, and the information about how, under what circumstances the holder may disperse the earnest money. And really nothing has changed. It's either when a property closes, if there is a subsequent written agreement between the buyer and the seller, and we lovingly refer to that as the T&R. It's actually the R, or release, portion of the termination and release. Or if there is a court order or an arbitrator makes that, that has jurisdiction, that has made that ruling. Or if the parties never enter into a binding agreement, or the one that ends up happening probably, I was going to say more frequently, but the most frequently one is at closing. In a situation where the holder is holding earnest money, the contract fails to close, buyer and seller do not agree on the disbursement of the earnest money. In other words, they don't both sign the release portion of a termination and release agreement. Then the holder, one of the options available to the holder is to do what we refer to as the 10-day letter, where the holder goes through the contract, the circumstances, to determine what happened, and send notice of their interpretation to disperse the money to one of the parties. We refer to this as the 10-day letter, and the reason we do that is once the holder sends out the notice of the intent to disperse, they have to wait for at least 10 days before actually releasing the funds to one of the parties, because the party not getting the earnest money does have the opportunity to send in a written objection based on the contract and what happened. So that's why we call it a 10-day letter. So what GAR has added in the mid-year revisions for 2023 regarding that process is it does state, and I do have it underlined here in paragraph B7B, that any party, real estate licensee, or any other person having knowledge of or interest in the disbursement of the earnest money may object to or provide information regarding the proposed disbursement by giving written notice of the same to the holder. So in other words, there are other parties, agents, licensees, other parties that have information as to what happened throughout the course of events from the point of the parties being binding to the point of it terminating, that is valuable to help the holder make an interpretation regarding the disbursement of the earnest money and the failure to close. Now moving on, again in paragraph B8, there is a section under the inspection and due diligence. And in essence, they just added one phrase that basically says the buyer has the right to inspect, meaning go through and check out the property through closing. And the seller is required to keep on all the utilities, so forth and so on. None of that has changed. What they have added is this section here that it says that the seller, okay, so this part has been the same, where it says the seller shall cause all utility systems and equipments to be on. This is what they've added in June of 2023. And all parts of the house to be accessible, including basements, attics, and crawl spaces, so that the buyer may complete all inspections. And then under the indemnification paragraph, I don't have this underlined, but they have added language that the buyer is not responsible for any defects that the buyer is not responsible for any damage resulting from actual defects in the property. So again, that was just changed just a bit to just clarify that information. Here is actually this last sentence is where it says that that notwithstanding the above, this indemnification obligation shall not apply to damage resulting from defects in the property uncovered during the inspection of the property. So if it was already a defect with the property, the buyer's not responsible for that. So that is an addition to the indemnification obligation. Then moving on, under the brokerage section, under the brokerage relationships in this transaction under designated agency, GAR just clarified and defined what a designated agency situation is. If the broker in this transaction is acting in a designated agency capacity, and here's where they added, where one licensee of the broker is exclusively representing the buyer and another licensee of the broker is exclusively representing the seller. And the rest is the same. They just defined what designated agency is. Also in this brokerage section under this disclaimer paragraph, that has been revised. It just added to or tweaked just a bit. And basically it has added that the broker, the agent is, the buyer and seller have not relied on any advice or representations of the brokers other than what is included in this agreement. Brokers have no duty to inspect the property for defects, hazards, so forth and so on and on and on and on and on, where the buyer and seller can have their specific questions answered, in essence, by a professional in that specific area. For example, construction expert, structural engineer, so forth and so on. And it goes on that the broker does not perform or have expertise in any of the above tests, inspections, or in reviewing any of those documents. And it just goes on to say that the broker and or agent by extension is not responsible for inspecting the property for those defects, hazards, conditions, repairs, so forth and so on. So again, it's very similar. It's just tweaked a little bit that to protect agents and brokers, we are acting within the capacity of our real estate license and not within the capacity of another expertise where the client or customer, buyer or seller would want to make sure to satisfy their questions with an expert in that area. Then under paragraph C, other terms and conditions, where it talks about the rights of the broker should either the buyer or the seller default on the purchase and sale agreement, they basically just changed it to say broker rather than every broker, just to clarify it and make it make more sense within the terms of the contract. Just a slight modification. And then under the definition section further down, and this is in paragraph C5. So let me go on down here under the definitions. They have just a really slight modification to broker. It says, in this agreement, the term broker shall mean the licensed Georgia real estate broker, brokers basically acting within the capacity of broker with respect to this specific purchase and sale agreement. And they have added the definition of what is a client and what is a customer. A client shall mean a party who is being represented by a broker pursuant to a written brokerage engagement agreement. In other words, if you've watched any of my videos or taken any of my classes, you will repeatedly have heard me say that in Georgia, for real property, the client relationship is contractually driven. A public person becomes a client of your broker by virtue of signing a brokerage agreement. Without their signature on that, they are not a client. By default, a public person working with your company, your firm, your brokerage, your broker, you, is a customer. And GAR in the purchase and sale agreement under the definitions has defined customer. And here it is under paragraph C5F. The term customer shall mean the party or parties who are not being represented as clients by the broker with whom the party or parties are working and for whom the broker may only perform ministerial acts. So as I mentioned, a customer, a public person working with your broker is a customer by default. They become a client by signing a brokerage agreement. So that's it for the changes to the purchase and sale agreement. I'm interested to hear what you think. If you like those changes, if there are any additional ones you think the Georgia Association of Realtors should make, comment below and stay tuned. I'm going to do probably 2 more videos, one on the changes they made to the brokerage agreements and authorization to show unlisted property. And then a 3rd one on the other forms, just some minor changes to some other forms. All in all, GAR did make revisions in June of 2023 to 20 forms. Some of them are just typographical or syntax errors. I'm not going to cover those, just the ones where there are changes to some of the content or concepts that you need to know as a real estate agent. Thank you guys so much for watching. Please check out some of the other videos and playlists on my channel. And I am Dana Sparks, broker of Maximum One Greater Atlanta Realtors and director of the Real Estate Academy of America, satisfying your needs with service, innovation, and education. Bye. If you like that video, check out the one here. If you like the content on this entire channel, please click here to subscribe. I try to take even the most complicated of real estate situations and make them crystal clear. See what I did there? Real estate made crystal clear. Thank you guys so much for watching.